Hello, there is so much going on and I need to catch up. With Karen Reed, the last time we made a video about a vivid bill. Okay, we're just getting back into it. I'm finally back in my house right now. Karen Reed, the last time we made a video about her, we talked about how the defense wanted to dismiss some of the charges against her because of what they learned from the people that were serving on the jury. We covered how the state responded to that, and now the defense has responded back. But before we get to that, I want to talk about some of the jury drama-ish, sort of jury drama. There is an emergency motion to extend the impoundment. Now, if you guys remember, Judge Canoni, she wanted to keep the names of the jury secret, and the jury just wants to make sure, okay, let's do this indefinitely because we don't want our names, we don't want our addresses out there because of fear of our safety. So let's read about that. And for those of you guys who are wondering, are you going to cover the Alec Baldwin stuff? Here's what happened, okay? I watched the beginning of the Alec Baldwin stuff, and then I had work to do, and then by the time I caught up with the rest of the day, I found that it was dismissed, and I was like, what the hell happened? So I think I watched the rest of it at 10 p.m. I stayed up till like 2 a.m. watching it. It was crazy. And I think the reason why I haven't really talked about it is because I was still processing it, okay? I didn't even do a live stream with you guys talking about it. My husband asked me, oh, why are the Alec Baldwin, why are the charges dismissed? And I was like, listen, it's just too much. Okay, there's a lot that happened, and I'm still just processing it. So eventually, I think I might do an Alec Baldwin video probably in a couple of days, but that drama was crazy. But anyways, back to the Karen Reed stuff. Let's read what the jury, they hired an attorney actually. Let's read their emergency motion and Judge Canoni's response to that. And then we'll go to what the defense's response to the state is. All right, are you guys with me? Get my glasses on. I hope y'all can read it. If not, I will read it for you. Findings in order on Juror Doe's Karen Reed. Oh, why am I reading like that? Juror Doe's emergency motion to extend July 8, 2024 impoundment order. Impoundment, what a very interesting word to use. This matter came before the court on the emergency motion of Juror Doe to extend the July 8, 2024 impoundment order entered by this court. Upon review of this motion and supporting documents, including the affidavit of Juror Doe, and the court makes the following findings in order. So we have an affidavit, and I'm going to read that to you guys. This case has garnered significant and divisive attention in Massachusetts and across the nation. True. 2, individuals associated with this case have been charged with intimidation, which charges remain pending. I think they're referencing Turtle Boy there. That's the only one that I know. 3, Juror Doe has submitted a detailed affidavit, which I find to be credible. 4, Juror Doe is a reasonable fear for their safety and the safety of their family if the list of jurors is made available to the public. That is a huge fucking issue. Can you imagine just doing your civil duty of just serving on the jury and you have to fear that people might come after you, people might dox you and your family? Like, that is just a huge no-no. But we don't know if that was going to happen, but we'll see what they say. Number 5, through the affidavit, Juror Doe has established a publication of the list identifying the names of the impaneled jurors will present a real and present risk of personal harm to the jurors and to the integrity of their service. Number 6, through their affidavit, Juror Doe has established there is a continuing risk of immediate and irreparable injury should the jury list be made available to the public at this time. Number 7, through their affidavit, Juror Doe has established a good cause to extend the impoundment order dated July 8, 2024 until and unless otherwise ordered by the court. This order shall not preclude any jurors from identifying himself or herself and or from speaking to the public about his or her jury service. So you want to talk about it, that's fine, but don't be identifying other people that were serving on the jury list. Judge Canoni, so ordered, July 18th, today. Now, this is what was filed by the jurors' lawyer. Yes, they had to hire an attorney for this. Oh boy, I feel like who is going to want to serve on jury duty now? Especially, since the Commonwealth have decided to go full speed ahead with retrying Karen Reed. Let's see if they change their mind, okay? Let's see if they change their mind. But so far, it seems like they're going to go after her. Emergency motion of interested non-party Juror Doe to extend order of impoundment of jury list. Juror Doe, an interested non-party, moves pursuant to Rule 6 and 10 of Trial Court Rule 8, Uniform Rules on Impoundment Procedure for indefinite extension of the order of impoundment, entered, I'm going to screw this one up, sua sponte by the court, Canoni, on July 8, 2024, impounding the list of jurors in the action. Juror Doe was a juror in this action wishes to maintain their privacy. Yeah, Fair enough. Let's look this up really quick. Of one's own accord. Sua sponte is indicate that a court has taken notice of an issue in its own motion without prompting or suggesting for either party. But I want to know how to pronounce it. Please don't be a meme.
So somewhat spontaneously, right? Sua sponte. Sua sponte.
Sua sponte. I think I had it right. Yeah, okay. Let's go back. In support of their motion, Juror Do submits that a real and present risk of personal harm to the jurors and the integrity of their service is ongoing. See Order of Impoundment. Therefore, there continues to be a risk of immediate and irreparable injury should the juror list be made public, and good cause exists for the indefinite extension of the Order of Impoundment. Because remember, in one of the jurors' statement, I don't know if it was through text messages or if this is the one that spoke directly to Karen Reed defense attorneys, but I remember one of them did say that initially it was a split between somewhere in the manslaughter charges. I don't know if it was like in the lesser charges or what, but there was a split, half and half. And then it moved from half and half to, I think, 8 people thinking that she was guilty and then 6 people saying she was not guilty. And that's where they were deadlocked. So it's possible that the remaining people that, the 8 people that voted that she was, sorry, did I do the math right? I don't know if I did the math right. It was 6-6 and then it was 8-4. Is that what I said? I think that's what I said. Hopefully that's what I said. It's possible that the people that voted 8 that she was guilty for, one of the manslaughter charges or the one beneath it, maybe they're in fear that, people are going to come after us for this because, we couldn't agree to her being not guilty for that. In further support of their motion, Juror Does relies on their affidavit and memorandum of law filed herewith. Also filed herewith are proposed findings in order and affidavit of service reflecting compliance with Rule 4 of the Uniform Rules on Impoundment. Wherefore, Juror Do, an interested non-party, respectfully requests the court grant their motion and enter the following relief. This is what they want. 1. Permit Juror Do to proceed using a pseudonym for purpose of this motion. Okay. Number 2, find that good cause exists for the extension of Order of Impoundment of the jury list in Commonwealth v. Reed. 3, extend the Order of Impoundment of the jury list in Commonwealth v. Reed indefinitely, but no earlier than July 16, 2025. Respectfully submitted, Juror Do, by their attorneys Andrew P. DiCenzo. Brief procedural history relevant to this motion, so we're getting to the meat of it. On June 9, 2024, the Commonwealth returned an indictment against the defendant Karen Reed, charging Miss Reed with second-degree murder, docket number 1. On March 26, 2024, the Commonwealth moved to establish a buffer zone surrounding Norfolk Superior Court during the trial of this action, see docket number 254. On April 4, 2024, the court allowed the motion after noting that it is well documented that protesters have shouted at witnesses and confronted family members of the victim, and that witness intimidation has also been prevalent in this issue. On April 12, 2024, a single justice of the Supreme Judicial Court, George J., upheld the buffer zone order, noting that demonstrations near the courthouse could expose witnesses and jurors to intimidation and harassment, undermining their ability to testify or to serve without fear of reprisal. Remember, I was pretty concerned about how the jurors were going to be transported from the courthouse to, I guess, their car and go back home. If it was like a secret area or if it was like somewhere that was like well hidden. Because remember when we were watching, when they were, after the mistrial was declared and there was cameras pointing at the courthouse and there was like the street right there. And I was like, oh man, are the jurors going to be able to make it out there without having anyone follow them or figure out who they are? Trial was held over several weeks between April 2024 and July 1st, 2024. The case went to the jury, but after several days, the jury were unable to render a unanimous verdict on all 3 counts of the indictment. On July 1st, 2024, the court declared a mistrial. Defendant moved to dismiss 2 of the counts of the indictment after the trial. Ms. Reed supported her motion with declarations from her attorneys recounting statements from jurors regarding the jury deliberation and interactions between jurors following the declaration of the mistrial. The circumstances of the trial and post-trial motion practice have further intensified emotions about the jury and its individual members. On July 8, 2024, the court issued an order of impoundment, impounding the list of jurors' names and addresses. Among other reasons for entering the order, the court remarked that people associated with the case have been charged with intimidation. This part touches on the jurors' affidavit, but we'll go over the affidavit as well. A, there is substantial risk of personal harm to the jurors. The public interest associated with this case is unique not just for its intensity, but for the extent to which segments of the public have become invested in the outcome and taken sides for and against persons affiliated with the case. Indeed, both this court and the single justice of the Supreme Judicial Court recognized that in imposing a buffer zone around the Norfolk Superior Court during the trial. The circumstances of this case continue to pose a unique risk of personal harm to the jurors. Juror Doe notes in their affidavit that the jury recognized the intensity of the public interest during the trial. Affidavit of Juror Doe 10. They heard protesters outside the courthouse yelling and screaming. I was wondering about that. After being discharged from service on July 1st, 2024, the jury was taken by a bus back to what was supposed to be a secret location where they observed what appeared to be members of the media. Oh no, including photographers. Juror Doe says that they were in so much fear on their way home from jury service that they pulled over to the side of the road to make sure they were not being followed. Holy shit. Each side of the issue appears to include persons willing to inflict or to encourage others to inflict harm on persons associated with the case. As the court is aware, there has been many accusations, at least one arrest and charge for witness intimidation. See Commonwealth v. Kearney. The blogger who has been charged with witness intimidation has characterized any jurors who did not vote to acquit the defendant as idiots who help cover up the murder. Juror Doe Affidavit 19. This accusation, of course, absurd, but is noteworthy because the blogger has demonstrated how he treats those whom he believes covers up murder. He has been accused of and essentially admits to harassing witnesses and has made statements to the effect of murderers and those who cover for them do not deserve to live a comfortable life. 20. The blogger has gleefully admitted to obtaining a public jury list. In a different criminal. I was like, wait, I don't want. Hold on a second. Where did they get this? In a different criminal case and shaming the juror who did not deliberate in the manner he preferred. That's not good. Some among the defendant's detractors pose risk of harassment and violence as well. Juror Doe is aware of dueling requests for harassing orders, of physical altercations between both sides. Juror Doe Affidavit 23 to 24, as released and described in the Boston Globe. We're actually going to go through the exhibits as well. That's attached to this. As released and described in the Boston Globe, and the people who were on the fringe of being interested in it are now engulfed. The anger level was at a 9 before, and now it's at 11.5. Oh, well, that's a very specific number, 11.5. The article characterized this increase as a rising rage. The article goes to quote another interview saying people are insane about this case. If they don't agree with you, they'll try to dox you. Yeah, that's just like a huge no-no. The jurors, if identified, are likely to become targets of harassment, abuse, doxing, and potentially violence. The nearly unprecedented and vitriolic public interest associated with this case is likely to put it squarely with the few instances in this Commonwealth where jurors have been threatened or harassed, as noted by Justice Gantz in Fujita. So that's another case. The court could be well within its discretion to find a continuing risk of personal harm to the jurors and the good that exists to permit them to remain anonymous if they choose to do so. The risk is not abstract, particularly because Commonwealth v. Reed is not over. Yeah, because the state, they want to charge her again. They want to do the case all over again. Ay, ay, ay. In the event of a new trial, the parties will need to impanel a new jury. Yeah, who's going to want to serve on that? No doubt that it will be a difficult task in any event, but if jurors from the first trial are identified and harassed, it will be even more difficult to find jurors willing to serve and potentially be subjected to the same treatment. Subjected to the same treatment. There is a real risk of the administration of justice and the parties' rights to a fair trial. The court should minimize this risk by extending the order of impoundment. All right, now let's get to the affidavit of Juror Doe. Let's see what they have to say. Now comes Juror Doe, a pseudonym who on oath deposes and says as follow. I will skip some of them. I was a member of the jury that was seated in the recently concluded trial in the above captioned case. Number 3, I just retained counsel to represent me. I don't know. I just find that to be really sad. You're serving on jury duty, and then because you're in fear of your life, now you have to hire an attorney to represent you, and that's money coming out of your pocket. I don't think that's something you get for free. I don't know if they're doing it pro bono, but you're gonna have to hire them and pay them. I don't know. That's just not good. It's just not good. Number 4, I read the impoundment order entered by the Superior Court Associate Justice Beverly Cannoni on July 8, 2024, which found that good cause exists to impound the list identifying the names of impaneled jurors in the trial of this case. As I read the court's order, it is scheduled to expire on July 18th, unless it is extended by the court. Oh, I didn't know it was going to expire that soon. For some reason, I thought they were good for, I'm probably just thinking Depp v. Heard, where the names were good for a year. Yeah, that's probably what I was thinking about. Number 6, I submit this affidavit in support of my request to extend the impoundment order entered on July 8. Number 7, I'm asking the impoundment order to be extended indefinitely because I'm in fear of my personal safety and the personal safety of my family if the names of the jury are made public. Number 8, I have read the impoundment order and noted the very first page that individuals associated with this case have been charged criminally with. Oh, they said individuals. I only know of one person so far. Were there more than one person that was charged with intimidation? I'm frightened for my personal safety as a result of learning that someone associated with this case has been criminally charged with intimidation. Number 9, I also recall testimony from at least one witness who described being harassed by individuals and her family being harassed because of their involvement in this case. I think that was with Jen McCabe's daughter, but I feel like Colin may have brought it up too. Maybe even Jen McCabe. I do not know any of the specifics of any such harassment, but I fear that my family and I will not be only harassed if the names of the jurors are made public, but that our personal safety will be seriously compromised. Water break. Wow. Number 10, during jury deliberations, we can hear protesters outside screaming and yelling. Number 11, during our jury service, the members of the jury would meet at what was supposed to be a secret location to be transported to and from the courthouse by bus. After being discharged from jury service on July 8, 2024, we were taken back by bus to what was supposed to be a secret location where we observed what appeared to be members of the media, including photographers. I was in so much in fear of my way home that I pulled over to the side of the road to see if I was being followed. Thankfully, I was not being followed, but what was and remains my mindset. If juror names are made public, we'll be constantly threatened and harassed, and there will be likely a physical confrontation at some point. Number 12, since being discharged from jury service on July 1st, 2024, I have read multiple news articles about the case and the attention that this case garnered across Massachusetts, New England, and the country. Why do they say it like that? I think I was expecting to say county. Number 13, there are clearly people who have very strong opinions about this case and about the jurors who deliberated over many days. I have seen articles, comments to articles, and postings about the verdict saying some very nasty and dangerous things. Some individuals have expressed outrage and anger that the jury did not acquit the defendant. I mean, I personally didn't think that the state proved beyond a reasonable doubt, okay? But they were, according to the defendant's motion, seems like they were stuck on the manslaughter part. But I don't think the state was even close to proving that, but that's my opinion. Some individuals have expressed outrage and anger that a jury did not find the defendant guilty. I mean, it led to a mistrial, right? That means Karen Reed gets to do a second one, but I mean, it's not really just easy, just like, oh yeah, let's just like, it's a mistrial, that's good. And then like, let's just try again a second time. It's still like that impending fucking suspense that you have, the money that you're gonna have to shell out and spend for your attorneys and all that. So, even though it was in a mistrial, it's still a lot. And then who knows when the new trial would happen again. But I mean, honestly though, we can't go after people that we don't agree with. If you have, like the jurors, right? Like I completely disagreed with maybe like, was it 8 people? 8 people? I disagree with them, but I don't think that we should go after them. I don't think we should dox them. I don't think we should, publicly shame them in any way. Like this is part of our justice system. We have to let it do what it does, right? Boy, I don't know. This is terrible. I feel really bad for this juror. If they still feel like they think people are going to come after them and stuff like that. But who knows? I don't know if well, let's read the rest of this. I'll see how I feel after I'm reading this, because I'm like, maybe they're just really paranoid because, now there's some jurors that are speaking out, and then they're talking about how, Karen Reed was acquitted of like the charge 1 and charge 3. And then maybe the jurors think they're like, oh shoot, they might come after me next. I don't want to be involved in this drama. I just want to do my civil duty and just be done with it. We're done with the trial. It's a mistrial. That's it. Move on. And maybe at this point it could be like, they're paranoid that, more people are going to dig into the jury list and figure out who everyone is and go after them because they didn't agree with their decision. So, 14. Just yesterday, I read an article in the Boston Globe with the headline, Karen Reed case ended in a mistrial, but the diehards haven't given up. See Exhibit 1. The 12th paragraph of this article, the administrator of the Karen Reed Focus Facebook group was quoted saying The people who are on the fringe being interested in it are now engulfed. The anger level was at a 9 and now it's at 11.5. The article characterized this increase as a rising rage. Let's go to the exhibit. Free Karen Reed sign. Judge in the Karen Reed trial declared a mistrial. It triggered a cliffhanger and in some an even deeper obsession. So this is the article that they're talking about. Dedham, the TV cameras have moved on. The man wearing the blonde Judge Beverly Cannoni wig is gone. Who is it in the picture? How are you going to reference that and not have it in the picture? The street is no longer lined with people bedecked in pink holding Free Karen Reed signs. It's a weekday afternoon outside the Norfolk Superior Court and where Reed supporters once reigned with their righteous outrage and their beach chairs. There is instead a farmer's market. I'm sorry, I thought it was kind of funny. A band plays Sonny Rollins. I don't know who that is. Should I know who that is? I'm sorry. The child climbs into a fire truck brought just for that reason. A woman carries an armful of sunflowers. Ooh, I love sunflowers. But the pastoral scene is deceiving. The July 1st end of the trial wasn't the end at all. It was a mistrial, a cliffhanger, an invitation for yet more obsession over a real life situation that's as sad as it gets, but for many has turned into a binge-worthy true crime drama. And they get to be part of the story. Those in the trial's groups are still out protesting, still fighting on Twitter and Facebook, still buying Karen Reed merch? Sorry, why did I read it like that? The Jackson Yannetti 2024 baseball caps. I haven't seen that yet. Named for the defense attorneys and make a nice keepsake. Instead, just 6 miles away from the Dedham court where they got so chummy, the old Karen Reed was framed gang reconvened last Wednesday. Once strangers, they had become people who hug hello and ask each other family and ask after each other's family members. Advertising. They have gathered in Canton, protesting in front of the offices in Norfolk District Attorney's Michael Morrissey, one of the many nemesis. We didn't see Michael Morrissey in that courtroom. It was all lolly, lolly, lolly. What was Morrissey busy with? What case was he trying? What was he up to? Lolly had to do everything, okay? Lolly had to do all the work. Morrissey's gotta go, reads one sign. Justice is coming, promises another. The weather app shows 88 degrees, but the air is thick and feels hotter. The group is huddled on the small patch of grass between the road and the enemy's parking lot. The shade is scarce, but crusaders aren't stopped by humidity. This is a busy week, says Scott McGinnis as he describes the demanding schedule of a Karen Reed diehard. Today, he is at a protest. He went on to one on Monday, too, in South Boston, outside the Massachusetts State Police Barracks. He spent Tuesday night at a meeting in the Canton Select Board, and tomorrow, Thursday, he'll be heading to Dedham to support the blogger known as Turtle Boy in court appearances related to his coverage. Oh, I think he had to go to court. I think I saw a picture of that. McGinnis's live in Shirley, and sometimes the commute to Karen Reed job takes an hour. Oh my gosh. Or more if the traffic's bad. But I feel like I'm letting people down if I don't, he says. It's been 2 weeks since Judge Cannoni declared a mistrial, leaving unanswered, for now, for some, the question of whether Reed drunkenly backed her Lexus into her boyfriend and left him for dead in the snow on the lawn in Canton on January 9, 2022, as the Commonwealth alleges, or whether she was framed for his murder by the people inside the house, as the attorneys argued. If you indulge in a brief coma on a mistrial day, such as this, is ongoing intensity that can be forgiven for thinking the trial is still in session, but not just because it's still spinning out on actual news, leaks about the jurors' thought, the motion by Reed's lawyer to dismiss 2 charges, the suspension without pay of State Trooper Michael Proctor, lead investigator in this case, and the suspension with pay of Canton Police Detective Kevin Albert, whose brother owned the home where John O'Keefe's body was found. An administrative erroneous Karen Reed-focused Facebook group says he's spending 3 to 4 hours a day on his responsibilities, approving new posts, writing his own, welcoming new members who are coming in droves as Karen Reed's fame continues to grow. The people who were on the fringe of being interested in it are now engulfed, says the administrator, a middle school teacher who identified by his Facebook name Do Greg. The anger level was at a 9 before, but now it's at 11.5. The rising rage he attributes to the assertion by Reed's lawyers that the jury reported unanimously agreed to acquit her on 2 of the 3 counts. I've got a fire lit in me that I didn't know needed to be lit. Paul Cristoforo, a restaurant owner and one of the informal organizers of the resistance. It wasn't early in the week and already plans were being formulated for weekend protests in spots from Auburn to South Shore, some at Rotary, some on the overpass. I'm just as active as I was during the trial, he said. People's rage take different forms. At least one Reed supporter who is unhappy with Judge Canodi's handling of Reed's trial has taken to Facebook to post a link in the Massachusetts Commission on Judicial Conduct so that others can easily file complaints against her. Many Reeds obsessive spend their time on X, reading endless posts that dissect once again and possibly forever what Karen Reed did and didn't say after she discovered John O'Keefe's body buried in the snow, and who did and who did not hear her say it, whatever it is. Then there is the trial highlight reels to binge for those who missed the good old days. One, a goodbye to our new friends, is a nostalgia-tinged montage of now familiar courtroom characters. The court reporter, the clerk, the cult favorite ceiling fan, with Sarah McLachlan's emotional "I Will Remember You" for a soundtrack. Jay, its creator, asked that his last name not be used because people are insane about this case. If they don't agree with you, they'll try to dox you. He's a former insurance adjuster who became so fascinated with true crime that he cashed in his 401k to start a trial-focused YouTube channel. His Reed montage was a hit. It got 1.7k likes. But even so, he found dealing with both sides of the case so unpleasant, he said, that he vowed to not cover a second Karen Reed trial. Could it be a person with the strength not to tune in for season 2? ? Oh boy, that was his first case that he covered, the Karen Reed one. I would say, yeah, that's probably a hard one to cover for your first one. I feel like you would need to slowly work your way up there because sometimes when you're covering a case, people will unanimously hate the person, the defendant. In this case, it was because it was such a shit show of investigation. And not only that, I believe that Lolly did not do a good job. I also believe that the witnesses, some very interesting shit going on with the witnesses in terms of whenever I wanted there to be a good explanation for what happened, I would sort of get the answer, but then there'll be more questions accompanying that. And it would just keep leading to more and more questions. And then I'm like, wait, what was the initial answer that I wanted again? I don't even know where I am. We're so lost. But yeah, I would say the Karen Reed trial is a very, very hard case to cover, especially if it's your first case. So, maybe they'll change their mind. Maybe they'll cover a different case instead. So, don't lose hope, whoever you are. What's his name again? Jay, right? Jay. Okay, yeah, you got this, Jay. Former insurance adjuster. All right, so that was Exhibit 1. Let's go back. Later in this July 15 Boston Globe article about another individual interviewed by the reporter stated people are insane about this case. If they don't agree with you, they'll try to dox you. I understand the term dox to mean that individuals will publicize someone's personal information. Yep. Including someone's residential address, occupation, business address, etc. Publicizing my personal information in this context exposes me and my family to unwanted and likely surprise encounters with strangers who likely have an axe to grind with any juror. 16. I have seen social media posts that are very demeaning of and attacking the integrity of the trial judge. If someone is going to attack a sitting judge, I see no reason why they will not demean, attack verbally, physically, a juror who sat on this jury. Number 17. I understand that there are individuals who are upset that an impoundment order was entered and they are actively seeking the identity of all jurors. I guess maybe because I'm not on Twitter, I'm not really in the trenches of some of the social media stuff. So I didn't really see anyone reporting about that or talking about like, oh, I got to get the names of the jurors and stuff. So that I'm not really aware of. But I could see maybe why. If people are super pissed that, she wasn't acquitted of all charges. 18. For example, my attorneys have made me aware of a video posted by a blogger/journalist, whom I understand to be a person who has been charged with witness intimidation related to the case, speaking about the trial and the juror's inability to reach a unanimous verdict on all counts after trial. In the video, should we watch the video? Maybe we'll watch the video. The blogger initially states that he has identified the jury for a person. What? He did? How? In this case, not only does the blogger state that he's identified the jury for a person, but also where this person lives and what the person does for a living. Why? That's so unhinged. Okay, let's watch the video. You gotta always watch the videos, man. You gotta make sure that they are representing things correctly. Let's see what they said. Julie Card 94.
No, I'm not wrong about Chauncey. I know I'm right about the foreman. I couldn't possibly have been more right. I know it is a fact. I know his name. I have his LinkedIn. I have everything. Seems like a nice guy. But I'm right. You're wrong. And I'm trying to get him on the show. We'll see if he comes on. Okay.
Of jurors' names during trial. That's one they're going for. Why do you think they want to impound the jurors' names? Because who outed the Chestnut juror? Remember that? The one woman on the who hung the Michael Chestnut trial in, what was that, July? The jury lists are public. So I got the jury list and I went down the list and I found the juror who hung the jury. And I shamed them, as I should, because it's shameful to do that to Sidney Chestnut and Michael Chestnut's parents and Michael Chestnut's kids. It's shameful. So why wouldn't I do that? Now, impoundment of
I don't know if this video is related. Is this video related? 19, the same video, the blogger demands to know the identity of the expletive idiot on this jury who did not vote in his preferred manner, and further that whoever did that subverted justice like they helped to cover for a murder. As far as I'm concerned, fuck them. That's what I think. Here's another status. Oh, is this the status right here? The blogger states in another video posted to X, which we already watched, who added the Chestnut juror. Remember that? The woman who, yeah, okay, that one, he already watched. Link to this post can be found here. Number 20. I understand the above mentioned blogger has been accused of harassing witnesses in this case, including by organizing crowds of people to harass them outside their home. And I'm aware that they have made statements in a blog from 23 to the effect of murderers and those who cover for them does not deserve to live a comfortable life, while Karen Reed suffers and fights for injustice for John O'Keefe. 21. If, as he stated, this blogger believes that the members of the jury on which I serve help cover for a murder, and he believes those who cover for murderers are legitimate targets of harassment, I fully expect the members of the jury will be subjected to efforts of harassment and shame, with a very real probability that some physical confrontation will inevitably occur. Number 22. My concerns are not limited to a particular blogger or to a particular side of this case. I'm aware that there are outspoken bloggers, commentators, and groups of people who wish for a guilty verdict on some or all charges against the defendant. I'm aware that there are physical confrontations between two sides of supporters. I think they're referencing, apparently there was a physical confrontation between, I think it was Turtle Boy and one of the Albert people. I haven't seen that video or really read anything about that, but my chat was telling me about that. I think that's what they're referring to. 23. An example of this is from two recent... Oh, okay, sorry. They were getting there. 23. An example of this is from two recent postings by an individual who appears to be a reporter from New Bedford. In today's post, she stated that she was in court today defending against a harassment charge against her and her pursuit of counter-harassment charge. See Exhibit 3. We shall. Now, so here's... Did we already talk about Exhibit 2? Did I miss Exhibit 2? Well, let's read Exhibit 2 and then we'll hop on into Exhibit 3. All right, let's do Exhibit 2. I think we did. Maybe they must have talked about Exhibit 2 and I must have missed it. My bad, guys. Canton cover-up, part 76. Chris Albert confronts loser woman in free Karen Reed shirt in Waterfall parking lot for taking his picture. Is that her? On Saturday, a pair of Turtle Riders, I think this is his website, right? Turtle Boy's website? Yeah, Aiden Kearney. Okay. On Saturday, a pair of Turtle Riders wandered over to the Waterfall Bar and Grill in Canton, which was the last place John O'Keefe was seen alive. They wore the new free Karen Reed shirts that everyone's been raving about. That's the Waterfall. That's the t-shirt. However, when they stepped inside, they saw a familiar face. Oh, God. Chicken Parm Charlie? Is that Chris Albert? The last time we saw him, he was kicking an award-winning journalist out of his pizza shop, thus denying access to Chris Albert's world-famous mediocre chicken parm. Okay. He then called police, claiming that he was some sort of victim, while periodically opening the door to call me a loser who is going to get it. Clearly, this man is on tilt because he knows he can no longer go out in public and live a normal life like he used to. That tends to happen when your family's involved in the murder of a police officer, followed by the subsequent cover-up and framing of innocent women. It appears as if Chicken Parm Charlie, who is an elected member of the board of selectmen, realized he's being photographed. However, instead of quietly accepting that people have the right to take pictures in public, and he is both an elected official and the brother and the father of men who have been accused in open court of murder, Chicken Parm Charlie decided to confront and berate these two women in the parking lot. He accused the women of giving this award-winning journalist a hand job, which is factually untrue, but it'll probably be more satisfying than his pizza. After that, she began to film. Watch. This dude can go in 5 seconds without calling someone a loser despite being a worse record in the court than the New York Jets. Okay, sorry. I don't know if I want to read this whole thing. But basically, it seems like some sort of verbal altercation happening there. Pretty long. Let's go to Exhibit 3. Exhibit 3. Jess Machado Show. This morning, the individual who's accusing me of harassing her at Norfolk Superior Court during the Karen Reed trial had an opportunity to be heard in front of a judge, but chose not to. Instead, she claimed that she now needs an attorney, as I counterfiled against this morning. When the judge asked if she realized there's no order in place that she would not get one done today if requested a new date, she said she understood and asked for it to be continued. We now have a new date of July 26th. There's no order. I was extremely prepared to not only defend myself against these ridiculous accusations, but I was equally prepared to prove that I am the one in need of protection. However, at this time, we'll be hiring an attorney to do the heavy lifting. Wait, what is going on here? Many friends and followers have offered to help fund my legal representation. I will take you all up on that offer later today. I will post a link to a fundraising option you can now use if you'd like to contribute. This is distracting from my work, as you can imagine, very stressful. The seemingly habitual exploiting of the court order protection orders by women in our court system is a real problem, and the only way to stop it is to fight back. I intend to do that. I'm still lost. What happened? So someone's accusing another reporter? I guess I'm assuming they're a reporter of harassing them, like the Karen Reed trial. Okay, I don't know. That's all I got from that. Yesterday, this reporter posted about getting protection from another blogger, see Exhibit 4. While I do not know the facts concerning these court appearances, it is very evident that individuals on all sides in this case have acted irrationally and aggressively over the past few years, which has caused multiple court appearances by parties seeking protection of the court from other individuals. Well, they're saying it's happening on both sides. 25. In light of the mistrial, there is no end in the sight in this irrational behavior, which clearly continues today. Jurors will undoubtedly be subjected to harassment and likely physical confrontations if names are made public. 26. My affidavit in motion should not be interpreted as indicating how I or any other juror voted on this case or how I or any jurors feel about this case. Every member of the jury, regardless of how they voted, is likely to face backlash from a segment of a large portion of the public who intensely follow the case. I wish to remain anonymous. I bring this motion on behalf of myself and other jurors who do not wish to be identified, regardless of whether or not we agreed during our deliberations. 27. It was an honor to serve on the jury. It was a significant sacrifice of time. How many weeks was it? It was like 2 months, not 2 weeks, but 2 months-ish, which I understand and anticipated when I was selected, which I did not anticipate, however, yes, was the likelihood that I and other members of the jury would be targets of intense public scrutiny and likely harassment campaigns strictly due to the outcome of private deliberations. If the jury names are made public, I will be subject to nonstop requests for comment about jury deliberations. I would prefer to not respond to these inquiries. However, what I fear is not only will I subject to requests for interviews that will be targeted and harassed because of what I did or did not do on the jury. I fear that verbal harassment will lead to physical confrontation and physical harm. I'm not prepared or equipped to anticipate or prepare any surprise personal attack. More importantly, I fear that I will not be able to protect myself and my family. Juror, I think they have legitimate concerns. And like I said, if you're serving on the jury, it's not something you want to do. You're not really getting paid for it. What are you getting, like $10, $15 maybe, and maybe free lunch? But you're sitting on there, you're sacrificing your time from your work, from your family, and, you're doing your civic duty. You should not have fear that people are going to come after you for serving jury duty. It's not like you wanted to do it. You're doing it because you have to. So here are all the exhibits. Is there any more that we should go over for the exhibits? Oh, what's this? Happy Monday. I figured everyone could use a good laugh for this weekend. TBT to the dark days before Jess Machado got Miss Grant Smith banned from court. Who is Miss Grant Smith? I didn't take this video, but it went to me on a Sunday afternoon in May after I set up Dr. Turtle Boy's chair. Show more. This video was entered into evidence and instrumental in me getting protection from Grant. Have to admit, I hate watching this, but it's a good reminder that you have to fight to stop people like Grant from attacking you, because if you don't, they will. But down McCabe. I love you. I love that he can't go to courthouse anymore. He treats everyone that way. Good job, Jessica. Takedown reveals never before inside story of how. Wait, what the? Okay. Oh, this is just an ad. Okay. Jesus Christ. I don't want to read the rest of that. I'm still a little confused what happened there, but I don't really care. I will link this doc for you guys. You guys want to read the entirety of it because I did jump around, but feel free. I will link it down below and y'all can read it. Okay, so now that we're done with that, let's get back to the defendant's response to the state. Remember, they have a hearing. I think, is it on Monday? Oh my God, time goes by so fast. Monday, yeah. Monday, July 22nd, they're going to appear in court. I'm assuming at that point it was going to be for scheduling to see, okay, well, when should we consider retrying Ms. Karen Reed? But let's read the defendant's motions and defendant's response, and let's see what they said. It's only 10 pages long, so not too long. Should I zoom in a little bit more? Oh, I can. Oh, cool. Very nice. Love this website. Defendant Karen Reed's replied to the Commonwealth's opposition to her motion to dismiss. Now comes the defendant Karen Reed, by and through undersigned counsel, and hereby respectfully submits this reply to the Commonwealth's opposition to her motion to dismiss. The Commonwealth's opposition is perhaps most notable for what it does not dispute. That, according to information from 4 deliberating jurors, the jury had reached a unanimous decision that Ms. Reed is not guilty on 2 of the 4 charges pending against her, namely counts 1 and 3. So I'm assuming the 4 jurors, maybe they are the ones that voted not guilty for somewhere along charge 2. And then it was the other 8 that thought she was guilty. I know 2 of them may have moved over, so before it's half and half split, and then it may have been. The reason why I'm saying maybe is because I think only one person said that in there. Only one of the jurors said that. So, what was I saying? Oh yeah, it went from 6-6 to 8-4. Okay, let's read. The jury has reached a unanimous decision that Ms. Reed is not guilty on 2 of the 3 charges pending against her, namely counts 1 and 3. The Commonwealth's insistence that Ms. Reed must nonetheless be forced to run the gauntlet once more is based on several clear fallacies. First, while the defense was giving an opportunity to be heard on other issues arising during jury deliberations, the appropriateness of the Tui Rodriguez instruction, the defense was provided no opportunity to be heard regarding the declaration of mistrial. So if you guys haven't seen my previous video about this, feel free to go watch it, because we cover the state's response, and then we looked at clip-ins because I wanted to go back and watch, okay, like, what really happened? I feel like it happened so quickly that maybe I didn't really have time to really process it. But I went back and we went back to the jury instruction that was given by the judge to see, was it confusing? If I was a member of the jury, would I have been confused? Would I have done what the jury did? And then we went back to when the jurors came back and what they wrote on their notes. Did it seem like they were deadlocked on all the charges, or did it seem like they were only deadlocked on one of the charges? To me, it seems like they were deadlocked on everything, because the way that it was written, it seems like they were just not close to getting anywhere. But it seems like they weren't getting close anywhere with just one of the charges, not the other 3. But that was my impression, right? And I think a lot of people thought the same way. But yeah, feel free to watch this video. I'll maybe link it at the end or somewhere around here. First, while the defense was giving opportunity to be heard on the issues arising from jury deliberations, the appropriateness of the Tui Rodriguez instruction, the defense was provided no opportunity to be heard regarding the declaration of the mistrial. I know that Judge Cannoni wanted to hear from both sides when the notes came. However, in the final note, after she gave the Tui Rodriguez charge, they came back again and said they can't come to a decision, a unanimous one. That's when the judge looked at them and was like, I won't do that to you. You guys, I'm going to clear a mistrial. And that's it. And no one said anything. No one protested. Lolly didn't say anything. Yannetti, Jackson didn't say anything. But also, were they given a chance to say anything? No, as well. Because the judge just said, okay, we're not going to do that to you. Let's go. Mistrial. There it is. Whew. Rather, upon receiving the final jury note, the court sua sponte declared a mistrial with no warning to or solicitation of objections from the parties. Second, the jury's note did not explicitly indicate an impasse on all the charge opposition at 1. To the contrary, it was readily susceptible to the interpretation proven correct based on information received post-trial from deliberating jurors that the deadlock applied to only multiple offenses included within the counts 2, but not to counts 1 and 3. Third and finally, the defense respectfully submits that neither the Commonwealth nor the court carefully considered alternatives before declaring a mistrial. The court reflects no discussion of any such alternatives, including, importantly, inquiring regarding whether the jury had reached an impasse in all, as contrast to just some of the counts. The underlying idea of the constitutional protection against double jeopardy, one that is deeply ingrained in at least the Anglo-American system of jurisprudence, is that the state, with all of its resources and powers, should not be allowed to make repeated attempts to convict an individual for the alleged offense, even if the first trial is not completed and the second prosecution may be grossly unfair. It increases the financial and emotional burden on the accused, which is what I mentioned earlier, prolongs the period in which she is stigmatized by the unresolved accusation of wrongdoing, and may even enhance the risk of an innocent defendant may be convicted. Consequently, as a general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial. Thus, whether the jury acquitted Ms. Reed or alternatively was merely not deadlocked on relevant counts, the Constitution compels the same result: dismissal. And see, this is where I was like, but since it wasn't recorded anywhere what the jury voted, if they truly believe that she was acquitted on count 1 and 3, it still wasn't recorded anywhere. And how, I don't know, where do you go from there? That's why this is so interesting to me. So I'm like, what's going to happen? Given the unambiguous post-trial evidence, it would simply be wrong to require the defendant to obtain 2 acquittals from 2 different juries for the same crime. The Commonwealth's leading argument is rooted in pure formalism that no verdict was entered on the record on court. Okay, I want to see how they address this. The opposition at 5. But precisely this formalistic mode of analysis has been consistently rejected by the United States Supreme Court and Supreme Judicial Court in a string of precedents spanning more than 100 years. The reception of the verdict and the discharge of the jury is but a ministerial act involving no judicial discretion. However, it may be in England, in this country, verdict was acquittal, although not followed by any judgment, is a bar subsequent to prosecution for the same offense. Hudson v. Louisiana, holding the judicial grant of a new trial prohibited retrial on double jeopardy grounds notwithstanding the state code of criminal procedure, did not authorize trial judges to enter judgments of acquittal in the jury trials. Indeed, the prohibition against double jeopardy was plainly intended to condemn the abhorrent practice of English judges exercising the power to discharge a jury whenever it appeared that the Crown's evidence would be insufficient to convict. I just don't know if this is like the same as what happened here. I also want to know how many other cases where, you know, the jury may have initially voted, hey, like, you know, let's we don't think that she's responsible for the major charge, so let's just like agree on that. But then let's move on to the second one. I don't know. I just wonder how many of the same scenario happened in other cases. Because I can see what Lolly was saying. Lolly was trying to say that, like, oh, you know, maybe the reason why they all said acquittal on charge 1 was because maybe they were, you know, going to move to charge 2 and maybe see if they can come to a compromise of some sort. But if they don't agree on, you know, if they can't agree on charge 2, then maybe some people would go back. Okay, well, actually, no, I really think it's charge. You know, I think she's guilty for charge 1. But I was only compromising on that to at least get her on charge 2. I don't know. The compromise thing I thought was a really good point that Lolly brought up. The Commonwealth's heavy reliance upon Bluford v. Arkansas fails for a reason set forth in the defense's motion. See motion 6. In that case, after the 4-person report of the jury was unanimous against conviction on certain charges, the jury was sent back to deliberations. The 4-person report was not a final resolution of anything, and there is no indication of the conclusion of deliberation that it was still the case that all 12 jurors believed the defendant was not guilty of capital or first-degree murder. However, by contrast, 4 deliberating jurors attest that there was a final, unanimous agreement that Ms. Reed is not guilty of second-degree murder persisting through the conclusion of deliberation. According to one juror, Juror D, after the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on counts 1 and 3? Alan Jackson's supplemental affidavit. Okay, so Alan Jackson, his argument against, you know, the compromising that I brought up was that, no, it seems like they all unanimously came to agreement based on what the 4 people said. But I feel like we would have to hear from the other jurors, you know, the other 8 to see if they agreed to that. Most importantly, like Bluford, this was not the case where the defendant was charged in a single count, which incorporated lesser included offenses. Indeed, the Arkansas law at issue in Bluford did not even permit the jury to return partial verdicts of acquittal, noting that the jury's options were limited to 2, either convict on one of the offenses or acquit them all. Here, by contrast, the defendant was charged with 3 standalone counts, and the state law expressly allowed for partial verdicts on any charges with respect to which the jury agreed. Oh, interesting. Only if the jury, in fact, was deadlocked on all 3 should the mistrial on all 3 be declared. Any other result would require either verdict, if a unanimous one has been reached, as an affidavit in this case reflect, or a minimum further deliberations. I guess, like, I don't even think the defense attorneys were even thinking about this, because had they had this in their mind, even though Judge Cannone declared a mistrial, I feel like these 2 defense attorneys, you know, they don't have a hard issue with putting their foot down or, you know, speaking up against the judge. I feel like they would have risen up and been like, hey, well, hold on a second, judge, like, you know, like, can we make sure that, you know, it's a mistrial and that they were completely deadlocked on all 3 results? You know, I think in their minds, they're like, okay, mistrial, okay, good. Let's, I think we'll take the win for now, right? And I think for them, it would have been good because, you know, who knows if the federal investigation, if the results are released, if they're concluded with that, it could have been favorable to Karen Reed, right? And also to do a trial again a second time. Well, now they can see Mr. Lally in action in trial, and then hopefully know how they can do even better. I mean, I think they did a really good job against Lally, but now now seeing him in action, now they're definitely gonna know what are the holes that they can definitely poke at and how they can perform better. I mean, same goes to Mr. Lally, right? Mr. Lally could probably do better on the second go around, but the lack of manifest necessity to support a mistrial provides a second independent basis for dismissal. Why did I say dismissal? For dismissal. While there's no doubt that a jury deadlock may constitute manifest necessity, the Commonwealth unsurprisingly states no support for its contention that a deadlock on some, but not all, separately indicted charges support declaration of mistrial, which respects all counts. Contrary to the Commonwealth's characterization as ambiguous. Opposition at 7. The jury note at issue here was facially susceptible to two alternative interpretations. 1, that the jury had to reach an impasse to all charges. Number 2, that the deadlock applied to only some of the charges. The multiple lesser charges include allegations within a single count, such as count 2. The information received from jurors post-trial proves the latter interpretation was correct. The jury's failure to expressly mention its agreement on counts 1 and 3 is understandable in light of the court's instruction that it should continue deliberating until it reach a final verdict on each charge. Yes, we re-listened to that in the other video that I made, and I would have had that understanding as well. It's like, okay, we're not filling out the verdict form until we agree unanimously on everything. But here's the thing. Before the jury instructions go back to the jurors, I mean, both sides, they can chime in, right? Defense included. So could that just be, I know that the defense is bringing this up, but it's also, doesn't it look bad for them as well that they didn't speak up at that point? Given that there was no deadlock on 2 of the 3 counts, it follows that there is no manifest necessity to dismiss the jury without receiving its verdict on those 2 charges. The defense does not suggest that a court was required to give the jury new options for a verdict, only that it should be asked the straightforward question of which the separate indictments they profess deadlock to. Because, I mean, since Judge Canoni gave that instruction and no one said anything about that, then shouldn't that just stand? Like, yeah, it sucks to find out, if the juries, if the members of jurors all acquitted Karen Reed on, if they all voted unanimously that she wasn't guilty of counts 1 and 3, yeah, that sucks. But, I mean, when the jury instruction was given, no one said nothing. In essence, the Commonwealth's contrary position asks this court to close its eyes to the possible, or even, as here, very likely, existence of partial unanimous verdicts on some, but not all, separately charged accounts to avoid the risk of one juror coercion. Opposition to 13, quoting Commonwealth v. Roth. The Commonwealth utterly fails to acknowledge that Roth, Bluford, and a juvenile are all clearly distinguishable because they arose in a context of lesser included offenses contained within a single charge. The Roth court's concern about coercion makes sense in that context. When the jury reports a deadlock on one charge, follow-up questioning regarding the possibility of reaching a verdict on a lesser included offense would imply the jury should consider conviction on that lesser offense. But this logic does not extend to the past circumstances, and no existing precedent cited by the Commonwealth requires judges to disregard the possibility of partial verdicts when the verdicts would be on a standalone separate charge, such as those in the current indictments. See Roth, 437 Mass. Rule 27B permits taking verdicts on less than all the charges set forth in separate indictments. Juvenile v. Commonwealth. Where a complaint or indictment on multiple counts charges multiple crimes, a general verdict could be returned as to one count despite deadlock on other counts. Providing that the court may declare mistrial in cases where the jury is unable to reach a verdict, however, it must first receive and record the verdicts which the jury can agree upon. Yeah, I mean, it just wasn't recorded, right? So I think that's another huge issue as well for the defense. There's simply nothing coercive about asking a jury reporting a deadlock that fails to specify which counts the deadlock relates to a single question of whether its deadlock is uncertain, but not all counts, and if it has reached a unanimous verdict on any of the counts. Commonwealth v. Foster, affirming trial judges taking of partial verdicts on 2 of the 4 separate indictments and observing to conclude that the jury could have felt pressure to convert provisional verdicts against the defendant in the final ones and to abandon all doubts that may have privately entertained runs counter to the clear instruction of the judge and amounts to a mere speculation without any support of the record. Commonwealth v. LaFontaine, affirming partial verdicts taken after the judge asked jury whether it had reached a verdict on any of the indictments. The inflexible prohibition on judicial inquiry regarding partial verdicts advocated by the Commonwealth would inevitably undermine defendants' important and constitutionally protected interest in being able, once and for all, to conclude their confrontations with society through the verdict of a tribunal they might believe be favorably disposed to their fate. Cruz v. Commonwealth, quoting United States v. Jordan, plurality opinion. And the danger of the unfairness to the defendant with multiple prosecutions exists when a trial is aborted before it is completed, as well as when the defendant is actually acquitted. Oh, does that mean, is Judge Canoni going to make her decision when we see her on Monday? Probably not, right? Do you think she's going to make her decision on Monday? I mean, she just got this on her desk, probably like today. I think this was written today, maybe yesterday. The Commonwealth's proposed rule would also undoubtedly hinder law enforcement interests by precluding courts from asking whether a jury may have reached a guilty verdict on some, but not all standalone counts. The Commonwealth's attempt to shift blame to the defense overlooks the black letter rule that the prosecution alone bears the heavy burden of establishing manifest necessity for a mistrial. The defense request for a Tui Rodriguez instruction did not, of course, reflect any implicit concession that the jury was deadlocked on all counts, nor did it commit the defense to any position regarding whether the court should sua sponte, declare a mistrial. A discussion with counsel, such as the occurring twice early in response to jury notes, that either the consent of the defendant to a mistrial or the further judicial inquiry of the jury instead was required. It is indisputable that a court provided no opportunity for a defense counsel to be heard regarding the declaration of a mistrial, as opposed to the appropriateness of a Tui Rodriguez charge. So the defense is saying, well, just because, we wanted them to read the Tui Rodriguez instruction after the first note came back, well, it doesn't mean that, we're complicit in the mistrial being declared. We just wanted the Tui Rodriguez charge to be read. In short, mere silence, absent an opportunity to object, does not amount to consent. Really? Okay, let's see what they say about that. The cases upon by the Commonwealth are readily distinguishable on the basis or even support the defense position. See Commonwealth v. Fetsaya. I'm going to butcher that. Holding that where the trial judge did not ask defense counsel to comment on a possible declaration of a mistrial, the lack of an objection from the defense counsel could not be construed as consent to such action. The judge declared a mistrial upon the defendant's request, Pellegrin v. Commonwealth, finding that the defendant had plainly had the opportunity to object, where the mistrial was declared after the voir dire and colloquy after the jury were cleared from the courtroom. In only one case cited by the Commonwealth, Fuentes v. Commonwealth, was the defense in the present case afforded no opportunity to be heard before a mistrial was declared. But there, the Commonwealth fails to mention the crucial fact that the jury's note preceding the declaration of mistrial expressly stated the jury could not reach a unanimous verdict as to either of the two indictments. Oh, okay. So that's a little bit different, because the note that we got, it wasn't clear that, the unanimous verdict, that there was a unanimous verdict on count 1 and 3. It was just like, oh, we just can't agree, There's too much differences set aside. I mean, it's not the jury's fault. It's not the jury's fault. It's not the jury's fault. Man, yeah, I mean, I think it would be great for the court to have a clearer way to do this. Like at the end, when Judge Canoni got that final note, I don't know, just do the polling. Is it bad to do the polling? Maybe there are reasons why they don't do pollings in mistrials. But man, I would want to know the polling. Or you want to ask more details, right? But maybe that's getting way too much into jury deliberation stuff that you're not supposed to get into, like the court's not supposed to get into. In those circumstances, while the more prudent course would have been to consult with the counsel, the record did not show that such consultation would have produced any fruitful alternatives. Here, the opposite is true. The note did not expressly state that the deadlock applied to all accounts, and it is patently clear from the affidavit submitted in the support of the defense motion that consultation with counsel may well have produced a fruitful alternative, namely inquiry regarding whether the jury had reached a unanimous verdict on any of the 3 counts. I don't know. Like I said, going back to the jury instruction, it just seems like it doesn't matter if they came with a unanimous decision on counts 1 and 3. It seems like if they didn't have a unanimous decision on everything, then you don't fill out the verdict form, right? Going back, that's how I looked at it. Which, according to the information, when jurors A, B, C, and D would have resulted in acquittals in counts 1 and 3, in any event, Fuentes did not alter the court's clear obligations. Repeatedly reaffirmed since that decision before declaring a mistrial. 1. Counsel must have been given full opportunity to be heard. 2. The trial judge must have given careful consideration to alternatives to a trial. Ray v. Commonwealth. The Commonwealth cites no support. We're almost done, by the way, guys. They cite no support for a suggestion that an attorney who receives a call post-trial stating the jury had acquitted his or her client must simply hang up with the phone and not act upon that information. The jury's agreement that Ms. Reed is not guilty on counts 1 and 3 reflects the results of its deliberative process. Motion at 4, citation omitted, not the contents of jury deliberations or thought process of jurors. Let's see. Remarking that a trial judge was rightly loath to examine the entire panel to attempt to determine the impact of the errant juror on the rest of the jury. The defendant is not relying upon the jurors to attest to any particular statement made or incident that occurred during the jury's deliberation, the effect of anything on any juror's vote, or any juror's mental processes concerning a verdict. Rather, the defense is relying upon the simple fact of the jury's agreement that Ms. Reed is not guilty on the relevant counts. Permitting jury testimony that a mistake was made in entering the verdict on the verdict form. The permissible subjects of juror contact listed by the Commonwealth are not exclusive. The Commonwealth fails to cite any authority establishing the fact of a jury verdict constitutes a prohibited subject matter under Rule 3.5c. At the same time, the Commonwealth criticized the defense for purportedly infringing upon the jury's deliberative process. It also paradoxically faults the defense for reliance on hearsay. But the affidavit by counsel in Commonwealth v. McCallum, attesting to alleged jury bias, was no less hearsay, and the Supreme Judicial Court squarely held that entitlement the defendant to further inquiry on the subject. The defense submits that the same result is warranted here. For all the reasons said above, as well as its opening motion, supplemental memorandum, and attached affidavit, the defense respectfully requests that this honorable court issue an order dismissing 1 and 3. So they are doubling down on it. They're like, hey, dismiss counts 1 and 3. Martin G. Weinberg, Yannetti, Jackson. Was Martin G. Weinberg in the courtroom? I know there was another gentleman who was like by the computer. Did he have glasses on? But it was all Yannetti and Jackson who did all the cross-examinations and direct examinations and stuff. All right, that's the defense's response. We'll see what the judge says. I wonder if she's going to make her ruling on Monday, this Monday coming up. What time was that hearing again? Let me pull that up. But like I said, based on the instruction that the judge gave to the jury, like I said, it seems like once they came to a unanimous decision, that's when the verdict form is filled. Not that like, okay, you know, once you come to some of the unanimous decision on some of them, then you can move on to the verdict form and then you can figure out, you know, which ones you're not unanimous on. I don't know. I think, I mean, to me, it just sounds like a huge battle for the defense. And, you know, if I was the defense and I heard about this, yeah, that really sucks. That really sucks. If you found out that the jurors, they deliberated and they were like, yeah, we cleared her, especially of the count 1, which was second-degree murder. That's a huge one. And remember, count 3 was leaving the scene, resulting in death. Charge 2 was the manslaughter one. And there was the lesser included, which was involuntary manslaughter. And then the other lesser included was motor vehicle homicide. Okay, what was I looking up? Oh, I was looking up the dates. I'm sorry. I got completely sidetracked. No, I don't want to download. So I'll see you guys Monday when we cover Karen Reed. What time was it? Karen Reed. Oh, you know, oh my gosh. Pre-trial hearing for Alexi Treviso. Wait a second. I gotta find out. I think the Karen Reed one is 2 p.m. their time, Boston time, which is 12 o'clock my time, I think. I have to find out what time Treviso is. If you guys haven't been updated with Alexi Treviso, I made a video about that recently. And then, oh, Adelson, case management. Okay, we got a lot going on. All right, y'all. Well, I hope you guys have a wonderful weekend. There's so much that's been going on. I'm finally caught up with some of the other stuff that's been happening. And like I said, I might make a video about the Alec Baldwin drama. Oh my God. It was so crazy. I can't believe it happened. Can't believe it. Morrissey. She let us down, man. Every time when I was like, oh, Adam Lawley, we're so spoiled by great prosecutors like Morrissey, like Georgia Cappleman, you know, or great attorneys like Ben Chu, Camille Vasquez, you know, we named a bunch of people. But then Morrissey, Morrissey, she really fucked up her case. Okay, I don't know what's going to happen to Ms. Morrissey. Is she going to be disbarred or what? Like, what's going to happen with her? Is she going to continue with the, I don't know. There's also a Hannah Gutierrez Reed, her defense team, also filed a motion as well. And we'll see what happens with that. Because Hannah Reed, I mean, she's been sent, you know, she's been serving her 18 months sentence, which I think she's already about 4 months in, maybe. When was she sentenced again? Was it in March? Something like that. Maybe before that. Oh boy, what a mess. What a mess. And not just Morrissey. Also very disappointed with that lead detective. I forgot what her name was. The lead detective, the one is it mean to say this? I thought she looked like one of those like 50s like Barbie doll. Her and then the crime scene technician. Like, what the fuck were they doing? Like, oh God, I don't know. What a mess. But man, the way that all went down, that was more juicier than any of the reality TV stuff that you can watch on TV. Okay, I could not sleep that night. When I watched it, I could not sleep that night. And then seeing Erlinda, I think, yeah, Erlinda Johnson, the other special prosecutor that was hired to assist Morrissey, and you find out that she quits that same day, and then she does an interview, and then we get to hear from, oh my, okay, sorry, it's so much. I might make a video, we'll see. All right, guys, I hope you guys have a good weekend. Take care. And I was supposed to stream on Twitch and do Elden Ring. Oh my God, are we still gonna do that? I think so. I don't know, it depends how long it takes to edit this video. Bye, have a good one. Take care. Join the Discord if you haven't already, and I appreciate you guys being here. All right, thumbs up, leave a comment below, and have a good one.